We have in our legal system a kind of bias against sneak law enforcement actions, and for good reason. We don't like sneak and peek warrants, the ability of law enforcement to kind of go execute a warrant in someone's house without them knowing, not disturb anything, and then leave before they get home. And those are, I think, good policies. But when it comes to DNA collection, I think there might be an appropriate use for a sneak DNA warrant that would minimize the harm or intrusion to the individual sampled when you're in an investigative stage. But also under the regulation and scrutiny and watch of courts, so that we can keep a tally of how often this happens, how successful they are, and make sure that it's not abused. A related issue to sneak sampling is the use of what I call rogue databases in the book. These databases are not overseen by state law. They're not authorized by national or state policies. They can be as simple as an Excel spreadsheet that's kept on a police department computer server. And they're essentially the DNA profiles of people who, by law, don't have to give DNA to a database, but somehow have given DNA to law enforcement. It could be a victim. It could be someone associated with the victim who gave an exclusion sample. It could be someone who volunteered a sample in an investigation because they knew they weren't the perpetrator and wanted to help police narrow down the suspect list. And the keeping of this information, I think, is legally and ethically problematic. There are now private companies that link these rogue databases. The sharing of the information is problematic. And yet we don't have a legal structure that is regulating when law enforcement is allowed to do this and how often in the vast majority of the states.